One of the things I learned early on in trying cases on the plaintiff side is plaintiffs win their cases when they prove all the elements of their case in a persuasive manner. The mistake I think a lot of plaintiffs lawyers make, and I did it sometimes as a young lawyer, is spending too much time trying to disprove the defense.
Hello and welcome to the Attorney Post, where we give you the inside scoop with top attorneys in their field. And now, here's our host, Justin West.
All right. Hello, everybody, and welcome back to the Attorney Post, where we discuss what's going on in various facets of the law with attorneys at the top of their game to help you navigate the ins and outs of various legal fields and jurisdictions. Because, as I always say, if you don't know your rights, you don't have any. Today, I'm very pleased to be joined by Ken Hoffman, who is on the masthead over at Mitchell Hoffman and Wolf, which is a PI law firm out of Chicago. Ken, how are you doing today?
I'm doing great. Thanks for having me on.
Absolutely, my pleasure. Well, before we get started, as always, we're going to jump right over and take a look at your website. So this is, I'm assuming you can share in the right screen here. I have two screens set up as well. Every so often, I just got a new side screen, and sometimes it doesn't go right, but it looks like it's fine. So there we go. So this is Mitchell Hoffman and Wolf. The law firm is mitchellhoffmanwolf.com. Very easy to know and spell. If you Google it, you'll find them just fine. But we will, as always, have a link down below in the description of this podcast episode. You can also call them at 312-726-6722. That's 312-726-6722. Kind of palindromic there almost, which is nice. And again, we'll have that down below as well. Mitchell Hoffman Wolf is a full-service injury law firm based out of Chicago. They do workplace injuries, medical malpractice, car, trucking, transportation accidents, nursing home injuries, police misconduct, and of course, assault and SA cases as well. We do have to be cautious sometimes in what we say on some of the podcast channels, so we'll often say SA versus what that actually stands for. But if you know, you know, and if you can read the page, you can see what we're talking about here today. So as always, if you need an attorney, if you've been injured, you're in the Chicago area, it sounds like Mitchell Hoffman Wolf will be a good resource for you. And again, we'll have all of their links down below. Before we get started, we are going to jump over and read from our sponsors. Our first sponsor today is Search Sift. Quick question. When somebody searches for a phrase like perhaps personal injury lawyer near me, are you actually winning those clicks, or are you just paying to stay in the game? Because Google Ads, it's an auction, and the more competing bidders, the more you pay. But before anybody clicks, Google is already suggesting what they should be searching for next, and that's where Search Sift comes in. They position your firm or your business in the predictive searches, so instead of competing, you're being chosen. And here's the kicker. You actually don't pay to rank with Search Sift. You only pay when somebody clicks on your website after they've completed a search. So instead of overpaying for the same cases like you're doing on a site like Google Business, Google Ads, etc., you're actually getting in front of the decision maker and getting, in fact, in front of the decision before it's made. Visit SearchSift, that's SYFT, searchsift.com to see what your market looks like or schedule time to speak with an expert. That's SearchSift, SEARCHSYFT.com. And as always, we will have a link in the description. Our second sponsor at the top of the hour is Groove Funnels. Entrepreneurs and dream chasers, listen up. If you're running an online business, it doesn't have to mean drowning in subscriptions or juggling a tangled tech stack. Groove.cm is actually offering a ridiculous deal where they give you everything completely free forever for life. Groove, I've used this for multiple things. I'm a web designer by trade. I still build a lot of my stuff in WordPress, but this is one of the coolest tech pieces I've ever seen. You can build stunning websites with group pages. You can launch high converting funnels. You can run email campaigns. You can manage e-commerce stores. You can run your own affiliate program, all of it in one place, all of it for free for life. No credit card required, which is crazy. They do have stuff obviously on the back end. That's how they make their money. But you can actually for free get started with groove.com, free for life. Just visit theattorneypost.com/groove. That's theattorneypost.com/groove to sign up today. Try it out. It costs you nothing to give it a shot, and you may find out that it actually replaces your messy tech stack, everything from ClickFunnels to website builders and email marketing and more. That is theattorneypost.com/groove. All righty. Stop and share and bringing this back over. All righty. So again, I am pleased to be joined by Ken Hoffman. Ken is on the masthead over there at Mitchell Hoffman and Wolf. And Ken, excuse me. He is a Chicago personal injury lawyer with more than 30 years of experience representing his clients in serious injury and wrongful death cases. Ken has handled a wide range of matters from car accidents and truck accidents to medical malpractice, again, worksite injuries, nursing home neglect, and everything else, securing numerous multi-million-dollar settlements and verdicts along the way to help his clients get back to life. What stands out most, though, is his client first approach. He tells every client, I work for you. Ken studied at Indiana University Bloomington and Washington University School of Law, and he's been recognized by organizations including Illinois Super Lawyers and the Leading Lawyers Foundation. Ken, welcome very much to the Attorney Post. And my very first question for you is always after my introduction is, I'm sure that was a mouthful to say and I missed all the important stuff. So question number one is simply this: what did I miss?
Well, you did a great job. And again, thanks for having me on the show. I think what distinguishes me and my firm from other firms here in the city of Chicago is our hands-on approach. We are a small firm. Me, Paul, and Jay started this firm back in 1998. We've always prided ourselves on being very selective in the cases that we handle. And because of that, every time that we take on a case, if you meet with us day one with the case, we are the attorney who's going to handle your case from day one until conclusion. We're not going to hand you off or pass you off to a young, inexperienced associate, someone who you don't know, or every time you get a call or an email, it's a new face or a voice. If you meet with Ken Hoffman day one or Paul Wolf or Jay Mitchell, we'll be there for your deposition. We'll be there at trial. We'll be there every step of the way for you.
That's a good pitch. I like that. So let me ask you this. What got you into law, Ken? Did you grow up on, I don't know, Perry Mason and you just kind of knew that law was where you were going? Was this midlife crisis and you're like, I'm jumping in, I'm going to try law? And what got you not just into law, but personal injury?
Well, law, I was not a big Perry Mason fan. I did watch a lot of television, police shows when I was a kid, Starsky and Hutch, things like that. And of course, the Brady Bunch as well. But what really got me into law was when I was in junior high school and high school in the state of Illinois, you are required to pass a Illinois and U.S. Constitution exam. And I really, really enjoyed the process of both of those. I really just took to it, really enjoyed learning about both the Illinois and U.S. Constitution, and that lit a fire underneath me. When I went off to college, my dad was a big believer in being a professional, and he gave me two choices when I went to register for classes with him back in June of 1984. Were you going to be pre-med or were you going to be pre-law? Again, I always liked history, social studies, Constitution more than science and math. So I became a history poli-sci major in Indiana. And then from there, I just pursued a law degree, which landed me at WashU in St. Louis.
Gotcha. And then once you were into law, what was the transition like going to PI? Did you immediately start off, you're like, PI is the thing, or did you dabble in a few other areas first, or?
I've always been in the personal injury area. My first job right out of law school was doing defense work on personal injury cases at a insurance defense firm here in Chicago called Clausen Miller. And my first job was defending auto and trucking cases, construction accident cases, and medical malpractice cases. After a few years there, one of the firms that I had a case against approached me and asked if I'd be interested in coming to work for them. And they were a plaintiff's firm. And they said, please bring over three transcripts from deps you took in cases that were not with us in the case I worked on with them. And I very quietly copied three transcripts and walked them down to their office. And I got a call back from the named partner, who was one of the early founding sort of leaders of personal injury law here in Chicago, a man named John Phillips. And John offered me a job. And that was back in July 1994. And that's what kind of brought me into the plaintiff side of personal injury work. But I've always been in the personal injury field, initially doing defense work on these cases, and since 1994 on the plaintiff side.
I have to assume that doing the defense side first actually kind of gives you a leg up in some ways. I assume that gives you an idea of what you're going to be facing when you're going, representing your clients against, say, an insurance company and their legal team. I assume you would agree with that. Or are there any particular insights you got that have really helped you in honing your skill?
It did. It was really a great insight into how the enemy, so to speak, works on cases. What I realized was that when I was doing defense work as a young lawyer, after every court appearance, after every deposition, after everything, the defense lawyers were always reporting back to their insurance company adjuster as to what had just transpired. They were always making new evaluations. So I direct most of my work on my files with that in mind, that whenever we leave court or there's a deposition, I know there's a report going back to the insurance company. And I want to make sure that every time I have an interaction with my opposing counsel on a case, and they're going to write a report back to their insurance adjuster, that they will report back that the plaintiff is prepared for his case, that the plaintiff's deposition went very well for the plaintiff. They were well prepared. Then when we took their client's deposition, that we were ready to take the deposition and we had our evidence lined up. We knew the facts of the case. Knowing all of that goes into the report that goes initially to the insurance adjuster, but eventually that adjuster reporting to someone above them who's making a decision on how much money they're going to put on the case. So I always approach every file knowing that every step we take is going to lead to a domino effect, reporting to the adjuster, reporting to the manager on that. And eventually that's going to benefit our client.
Gotcha. No, that makes perfect sense. And that's exactly what I would actually expect to see. I like that you care how they viewed you. It was basically like getting a report card from your opposing counsel that says this guy knew what he was doing, which is always nice to see. I have to assume. So that's quite the attaboy, right? It's quite you love it when the opposing party
Right. You'd hate for the opposite to happen where they write a report back to their insurance adjuster saying the plaintiff was not prepared for the deposition. He didn't seem to understand the medicine. He didn't seem to know the facts. Because once they see that, that makes them think that you're not ready to try the case. And everything we do has to be designed to make them believe that they don't pay us the right amount of money, the top dollar on the case, that we are willing to take the case to trial in front of a jury and obtain what is the full and proper value of the case for our client.
Yeah, it makes sense. Absolutely. So let me ask you this. Now, I'm a firm believer that you step up to bat enough times, nobody bats 1,000 forever, right? And I'm sure starting out in your legal career, you've probably had a few times when you swung and you missed, right? Everybody has a failure, but I'm a firm believer also that no failure is really a failure as long as you're learning something from it along the way. It's just more of a slow burn win. So can you let my listeners know about a time in your practice of law where you experienced a setback, of failures, maybe a case didn't go your way, a witness said the wrong thing, but what did you learn from that, and how do you make sure that you're bringing that knowledge forward to always be given the best care for your clients?
Right, like you said, even every loss, every negative experience should be a learning experience as well. And one of the things I learned early on in trying cases on the plaintiff side is plaintiffs win their cases when they prove all the elements of their case in a persuasive manner. The mistake I think a lot of plaintiffs lawyers make, and I did it sometimes as a young lawyer, is spending too much time trying to disprove the defense. You don't win a case by disproving the defense. If you prove your case, if you prove the elements of a malpractice case, if you prove the other driver was negligent, if you prove they caused the injury, that will on its own disprove any defense. But when you're chasing your tail, trying to disprove some red herring defense that's been put out by your opposing counsel, you're not proving your case and you're playing into their hands.
That's good advice, actually. I like that a lot. That makes good sense. So kind of the flip side then, it wasn't so much of a failure, but what is one of the things in your legal career that you're most proud of? What's one of the proverbial feathers in the cap, right? Where you think back and maybe it was a case that you thought you weren't going to win. And not only did you win, but they decided a crazy settlement for your client. Or maybe it was just when you got to see, I mean, obviously, I'm sure that has to be part of the issue is when you get to see people start to become whole again after an accident. And I've always respected PI law specifically because that's really what you guys do. You are a stopgap. You step in an area where people don't have materials, they don't have the resources to hire an attorney. And you guys make legal help possible, which I love. So tell me about one or two of your biggest successes or the things in your legal career you're most proud of.
A couple examples come to mind. One was a medical malpractice case that we tried several years ago that resulted in a $9.9 million verdict for our client. It was a wrongful death case. A young mother was receiving prenatal care while she was pregnant from a local Cook County health clinic, and she was being seen by a nurse practitioner. The nurse practitioners are really valuable parts of the healthcare system, but they are physician helpers, they are physician assistants, they are not doctors. And our client, had a well-recognized complication in her pregnancy called preeclampsia, which is marked mainly by a rise in blood pressure and protein in your urine. And it's a disease that only a pregnant woman can get. A man can never get it. And a woman only will have preeclampsia during her pregnancy. That's why for any of our female listeners out there, when you go and you're pregnant and you go for a prenatal checkup, they always check your blood pressure and they check your urine for signs of preeclampsia. Well, our client was going to this clinic being seen only by a nurse practitioner and never by a physician. And she developed an increase in her blood pressure. She developed protein in her urine. And at no point did the nurse practitioner ever advise the physician of this. She tragically develops full-blown preeclampsia. At the time of delivery, she suffers a stroke as a result of the preeclampsia, and she dies, leaving behind her husband and 3 small children. When we first filed the case, the lawyers for the county told us that they were not responsible. They raised a series of defenses that were without merit. But what really broke the case was finally at trial, we called the head of the clinic in, and the head of the clinic finally admitted on cross-examination that it was the obligation of that nurse practitioner to report these findings to a physician. That had the findings been reported, the patient would have been treated sooner and would have survived without what happened. So that was a really great moment for us. The second one would be another case against a governmental entity. It was a police chase case where our client suffered a really horrible neurologic injury. And the case was tried the first time. It was a hung jury and a mistrial. And we had to come back and try it again 6 months later. And that second time, we were successful in winning that case, and it resulted in a $3 million verdict for our client. And what stands out in my mind was that the jury came back fairly quickly in that second case, which is usually a bad sign for a plaintiff. It means that usually there's a defense verdict. And the lawyer for the city of Chicago came to hear the jury verdict read with an order already prepared that said not guilty. And when the jury came back with a $3 million verdict for our client, he asked me if I wanted to write the award down. And probably was not one of my greatest kindest things, but I said, no. I said, Matt, you've already got one started. Why don't you just finish it? So I don't believe in spiking the football too many times, but that he showed up so arrogantly with that order already prepared, I felt I had to spike the football that one time.
That's awesome. I like that a lot. That's hilarious. So this is a related note, and this is actually my favorite question to ask attorneys. I didn't give this one in the pre-roll, but I find that especially in PI law, and you deal with so much tragedy, and we're going to come back to that topic in a little bit. Obviously, a mother dies, that's horrible. But I also find attorneys deal with a lot of absurdity. I mean, they just do. I'm sure you've had just people maybe bring ridiculous cases, or you've had witnesses say ridiculous things. You've had judges in 30 years of law practice plus. I'm sure you've experienced some absurdity. What's one or two of the most absurd things you can think of that you've experienced in your practice of law? Just the things that make you shake your head and you know, wonder if their cornbread ain't done in the middle, as they say.
Well, what always shocks me is the way our cases are handled here in Cook County and most courthouses is that there are periodic case management or status calls where you show up and the judge wants to know where you are in the course of discovery and wants to know if you're sticking to the discovery deadline the court has put in place so the case can keep moving towards trial. And as a plaintiff's attorney, we work on a contingent fee basis that you don't get paid until your client wins. And what I'm always amazed at is how many lawyers show up in court and they haven't done their homework, so to speak. The judge asks, have we taken the party depositions? And the answer is, no, we haven't. Or have we taken the treating doctor's depositions? Have we disclosed their opinions and their records to the other side? And people say, no, we haven't done it yet. I never understand not doing your homework, so to speak. Your job is to represent your client as effectively as you can. And if you're not pushing the case and getting your work done, you're not going to get the results for them. The second thing is when they send over a young, inexperienced lawyer, or even maybe an experienced attorney, and the judge asks, what's going on with the case? And the response is, Judge, it's not my file. If you're in court that day, it's your file.
It's your file.
So you have to always do your homework and know what's going on. But it always shocks me, no matter how many times I hear it, when people say, Judge, we didn't get it done, or two, it's not my file. Those things always just make me roll my eyes.
Here's a very important question. Very, very important, very serious. I need you to put on your serious face for this one,
Okay.
right? I know you didn't watch a lot of Perry Mason, but do you have a favorite pop culture attorney?
A favorite pop culture attorney? Let me think about that one.
Fictional or non?
I do watch a lot of television. Well, I can't stand the Lincoln Lawyer. sorry for everyone's a fan. I think it's just a little bit too silly. But I think the TV or movie that best reflects what it's like to be a plaintiff's personal injury attorney is Paul Newman in The Verdict, which is
Hmm.
a older movie. If you haven't seen it, it's definitely worth watching. Great cast. It deals with the effort and hard work that goes into being a plaintiff's lawyer in a medical malpractice case against a powerful insurance company and hospital. So if you haven't seen Paul Newman in The Verdict, I think that's a great one to see.
That's good to know. I actually have not seen that one. One of the most common ones we get, other than like, your Law and Orders and whatnot, is My Cousin Vinny. A lot of people love that one. They say, "Oh, that's a very accurate representation of law."
I do
But
love that movie. I know I didn't think that that's a great movie. Also, I don't think of it as being a true courtroom movie, but I do think that's a great movie. And whenever it's on, I definitely stop and I will watch a scene or two out of that movie.
worth
So that's
worth
a good one
vegging,
also.
worth vegging out to. That's awesome. Okay, so let's dive a little bit more into the more meat and potatoes of what it is that you do. Here's my first question for you, and this is one that I guess I'd like to give you a chance to clear the air a little bit. What's one of the biggest misconceptions people bring into your office about what you can and can't do? That you, if you could just disabuse people of this one thing, what would it be?
That just because you're injured doesn't mean you have a case. Oftentimes, people will fall walking on a sidewalk or fall in a department store, and they believe that just because you fall and you suffered an injury, which is always very upsetting to people and sometimes very serious, that automatically the property owner or the property manager is responsible. That's not how it works. You still need to prove that there was some negligence on the part of the landowner or property manager, that you still need to prove your case. Same way with people who might be at fault in an automobile accident. They suffer an injury, but they were at fault for causing the accident. And you have to explain to them that you were the negligent party and therefore you're not going to make a recovery. So it's not just you show up with a broken arm or broken leg and a check comes out of the ATM machine. The plaintiff's lawyers must prove their case. They have to show duty, breach, injury. That's a really important thing to keep in mind. And lastly, oftentimes value in a case can be determined by the amount of insurance that's available. If you suffer a very, very bad injury and the at-fault driver only has a $25,000 insurance policy, you don't have any underinsured coverage to step in, the value of the case is going to be $25,000, which is sort of sad to know, but it's a fact of how the system works.
Gotcha. So when a serious injury or a wrongful death case first comes in, what are you looking at right away that tells you what kind of a fight this is going to be, other than obviously the insurance amount that's possibly on the table?
Well, the first thing we always look at are what are the facts of the case. Serious injury comes in, as I said, does not mean you're automatically have uh, a valid case. Look at the facts of the case. We'll obtain the police report. We will then, from there, try to conduct our own investigation into what may have happened, see if there's any video surveillance cameras. It's very typical now for business to have surveillance cameras around there. Even Ring doorbells can be very helpful in the investigation. Once we get a good grip on the facts, you want to know who are the potential defendants in the case. Was the driver working for someone? We had a case several years ago where it was someone driving their own personal vehicle, but they were delivering material from their place of work to another location, which then triggered an argument that they were working in the scope of their employment, which brought more insurance into the case. We look at the facts of the case. We want to know who the proper parties are going to be in the case. Then we want to know what was the treatment course that our client pursued. Did they go right to the emergency room from the scene? Did they follow up with their doctors when they were told to follow up? Did they go to all their physical therapy appointments? I always remind my clients that you're having pain even after the treatment. You've got to go back. You've got to let the doctors know, because if it's not in the medical records, the insurance company is going to say, well, the records don't mention anything about there being pain or ongoing complaints. So all these things, step by step, play a role in how we evaluate the strength of the case and what the dollar value might be down the road.
Gotcha. So when you're working hard on a case, it involves an enormous loss, a tragedy, a death. How do you balance being that strong advocate for your client, but also being someone that your clients can lean on? Is there a tension, and how do you decompress from that stress? Because I know that in PI you have to deal with grisly stuff sometimes. You have to look at pictures that you would rather not see. You've got to deal with, accident issues or, SA abuse issues, and you have to deal with horrible, horrible parts of life. How do you bear that stress?
I try to be a good listener. For me, we have several cases working on at any given time, and over the course of my career, hundreds of cases we've worked on, not thousands. But for every plaintiff, every client, it's their only case most likely. And I try to be a good listener. I try to hear what they have to say. I try to understand what they're going through. And I base my approach on what that particular client needs. Sometimes they need someone just to let them vent and say what's on their mind. Sometimes I need to step in and explain to them, hey, that's not how the system works. But it's really a case by case approach. Again, almost all my clients have my cell phone number. They know they can text me and call me at any time they want within reason. And I'll always get back to them. I remind them I work for them. So there's no one size fits all. But sometimes they need someone who they can just yell and scream at for a few minutes. Sometimes they need someone who can just tell them what's going on and what's really going to happen. But being direct with them is always a good approach.
Gotcha. So over the years, you've been practicing for 30 years now. Have you noticed, I don't know how to say this in the clearest way possible. Have there been changes in the insurance defense playbook, or have they like tried to standardize certain things where if we see X, then we argue Y and we win 58% of the time or whatever? Like, what has changed in the last 30 years in PI?
I think the biggest change that I've seen in, I'll call the automobile area of personal injury cases, is how tough of a line the insurance adjusters take pre-suit on a case. We don't handle a lot of cases pre-suit, but the ones that we do, the insurance adjusters take a really hard line, almost lowball approach to every personal injury case, hoping that the plaintiff's lawyer or the plaintiff, him or herself, will take a lowball offer or short money, as we sometimes refer to it, and not put the case into suit. I think they really, really try to see how many cases they can undercut, as early as they can. I don't know that there's a whole industry-wide approach on that they've gotten together to form, but I do see it more and more often that they take a very hard line, low ball approach early on in cases. And sometimes we'll give an insurance company one chance to make a decent offer on a case. If they don't do that, we put the case right into suit, we march towards trial. But to go back and forth, play ping pong with small, insufficient offers doesn't do your client any good whatsoever.
I was going to ask you, and you just kind of answer that question. So when an insurance company does exactly that, does that almost light a fire under you?
Yeah, I mean, I think you can't get angry because getting angry doesn't really help you. You have to realize that you gave them their one chance to be reasonable on a case, and they didn't take it. So at this point, you march forward. You don't go
How do
back.
you
Go ahead.
you make that decision about whether or not the offer is reasonable? How do you help a client make that decision?
Well, you try to explain to them what you think are the realistic opportunities or possibilities to settle a case. Um, for example, say you think the case is worth, I'll make up some numbers here, is worth $250,000, and they're offering $247,500, and um, they won't go any higher than that. Well, you explain to the client that the case may be worth an extra, little bit of money, but that's going to take 2, 3 years to get. It may be there, it may not be there, but we're going to spend maybe $20,000 to get there. I try to explain to them what the cost benefit analysis is on taking the 247 right now versus the 250, maybe 2 or 3 years from now. And if there's bigger gaps in there, if it's 1 million versus 5 million, the math is pretty simple. But when it's
Yeah.
a smaller gap, there is a cost benefit analysis to it for the client. And I try to explain to them how it's going to work and what the value is of money in your pocket today versus 2 or 3 years down the road.
Makes sense. In a catastrophic injury case, or a wrongful death case, how do you help a jury understand the full impact of what was taken from somebody?
try as best I can to talk about it in real life terms. You try to take the injury, the medical jargon out of the whole thing and talk about what that means for the person themselves. I'll give you an example. In the case I discussed earlier about the with the city of Chicago, which we had to try twice, the client suffered what's called a brachial plexus injury. They all the nerves that lead from their spinal cord to their right arm, which was my client's dominant arm, had been pulled away, and the client was left with a withered arm that was basically without any function at all. And it's one thing to talk about that in medical terms, about the brachial plexus and the nerves and all that. But what we did was I had my client during his testimony explain all the things he couldn't do. And I remember it was painful to watch, but I asked him to take off his shirt in front of the jury and try to put it back on by himself, which he could not do. He needed help to do that. And until the jury saw how difficult it was for our client to simply get dressed every day, could they understand that? And I remember thinking to myself, is the jury going to think I'm being cruel? And that wasn't my goal. But I think the only way to really understand the nature and extent and how disruptive the injury was, to let the jury see what it means to not be able to get yourself dressed as a grown-up adult man or
Yeah.
woman in that case. It's something that people don't appreciate. You can say, yeah, I can't get dressed in the morning, but until you watch someone not be able to get dressed, it's hard to really appreciate.
I have to ask, did your client know this was going to happen beforehand, and were they appropriately attired in undershirt or?
I told no, we had told them what we were going to do. It was, yeah, I mean, sort of, you don't want to ever do something that you're not prepared for. And we told him what it was going to be. And he didn't, he didn't have to, what's the word, milk it for anything more than it was worth. I mean, just to even get his shirt off, he could do the buttons with his one good hand, but then to get himself out of the shirt was something that it's hard to describe. Unless you saw what happened, it's hard to imagine trying to get your arm out of a sleeve when you have no motor control of the
Yeah.
arm. And again, the jury didn't appreciate that until they saw it. And I'm not sure I really appreciated it fully until I saw it either.
I think it's very creative. I think one of the things I really like about PI law is I have seen some of the most creative legal aspects come out of some of the ways that you guys used to do exactly that, to prove the case, to describe it in a way that's visceral and that people can really understand. Let me ask you about juries just for a second. I'm curious, have you ever actually sat on a jury? I say this because I am currently right now on jury duty, which is to say I got notice and I have to call in every 2 weeks to see if there's a case. I live in a tiny town of, 7 square miles and 10,000 people. We have like 3 cases a year. So I'm probably not actually going to wind up. This is my third time getting called for jury duty and not going. But have you ever been on jury duty, or have you ever been called and then people are like, oh, he's an attorney, get rid of him?
I've never been, well, actually put onto a jury. A couple times, the way the system works in the county where I live is you're told to call on the Friday before after 3 p.m. to see if you're required to show up for jury duty. And 2 or 3 times I've been put on that list and I've called. I've never been asked to actually appear. So I know what I'd love to be on a jury. I'm not sure I ever would get selected for a jury, but I would love the opportunity to sit on one and sort of see from the other side what it looks and feels like.
Yeah. They make psychologists get psychoanalyzed before they can practice. I feel like an attorney should have to sit in the jury box. But I also understand why other attorneys would want to not have you there. It would be an interesting case. So let's talk about expert witnesses. In your experience, what makes a witness persuasive? Do you have regular witnesses that you call up on a frequent basis? Is it always on a case by case basis? Is it a doctor, a client, or an outside expert? How do you make those decisions?
Well, we don't have any in-house experts, so to speak. If I use the same expert on more than one case, yes, but I'm very leery of having someone testify for my firm on several cases. I think that's a really easy cross-examination point for the defense to have them say, Dr. Smith, you testified for Mr. Hoffman's firm a dozen times over the last 20 years. That doesn't look good. So our approach is before we hire an expert, we talk amongst ourselves as to if you ever had someone in a certain discipline. That's one way to do it. Oftentimes, I have a lot of friends who do the kind of work that I do. We're all friendly competitors here. And we'll share names with each other. Who's a good expert you've used, who's an orthopedic surgeon or a neurosurgeon or a nephrologist or things like that. And then once we get those names, we'll talk to the witness. And sometimes just being the smartest uh, doctor or having the best resume isn't what's all that important. What's most important is being able to communicate the facts to a jury. I'll never forget in a med mal case that we tried a few years back. The defense expert was a very, well recognized expert in the field the case was about. And our client or our expert was just a regular practicing OBGYN here in town. And at cross-examination, they were cross-examining our expert about literature and all this. And our expert's line, I'll never forget it, was those are really great things to worry about if you're doing a study in a research university. We treat patients, and if you wait for those things to happen, a lot of people are going to die. You got to treat the patient that's in front of you. And so the defense expert was talking about research studies and this and that, and variations from the norm and all these things the jury didn't care about. Our expert talked about this is how you treat a patient, and that's really what made a difference. So common sense.
My next question was actually going to probably dovetail into that one perfectly. And it was simply this: has there been a moment in court or in a deposition where everything suddenly turned either in your favor or against you? I mean, that sounds like one where the witness came in and said just the right thing and kind of shifted the mood. But has there ever been a case where maybe even the opposite has happened?
Yes, I've had work against me. It's not a really great feeling. It's a much better feeling when you are the beneficiary of the gotcha moment or the slip up. But there's nothing worse than when you know, see your expert make a left turn on you when you weren't ready for it. But you have to keep your poker face and hopefully get up on redirect and try to clear it up as best you can. But it's a tough field. No case is perfect. No case goes in perfectly. There's always some bumps here and there. And, there's two sides that are competing for their version of the truth. So you have to be ready for things not to go well. It's kind of like if you're a sports fan. Sometimes your team's on a good run, throw a good 10-0 run. Sometimes they're on the other side of a 10-0 run. You got to, stop the bleeding, so to speak, no pun intended, and try to turn the tide the other way.
Absolutely. You deal with medical malpractice cases. You deal with nursing home abuse cases. How do you work to make them accountable, particularly when I know sometimes institutions can kind of close ranks, right? And do what they can to kind of squeeze you out or make it more difficult for you to do your job. How do you pursue justice in those moments?
Well, I think that, again, what's most important in a medical malpractice setting is to simplify the cases down to ideas that the jurors can understand. Most jurors have a hard time understanding how you take out someone's appendix or perform neurosurgery. Those are really tough cases to win when you're trying to argue that the surgical technique was not proper. Because again, no juror knows how to take out someone's appendix for the most part or perform neurosurgery. But when you can break it down into a system failure, a failure to properly communicate, a failure to properly respond to certain lab values or signs, jurors can understand that. So you have to really break it down to things they can comprehend and deal with in their everyday life. Everyone understands that if you don't properly communicate information or you don't properly respond to information that's available to you, that's going to cause an injury. So I try to always break it down to one of those two things.
Gotcha. So at this stage in your career, again, 30 years successful practice beyond
35 actually now.
35 years. I apologize. I won't tell you that I was 10 years old when you started practicing.
I'm getting used to it. That's kind of the funniest thing. I was always the youngest guy in the room for a long time. Suddenly I'm on the other side of that.
And all of a sudden you're not. Well, I'm actually in that transition right now. So I'm 45. I have two kids in college, and we always had the youngest kids in the group. We had all the older parents and whatnot. And all of a sudden now we're the old parents. People are like, oh, you got kids in college. My goodness. And I mean, I have a friend, kid you not, I have two friends with 11 kids, different families, both with 11 kids. And one of them is already a grandfather with two on the way. So I always have to give him a hard time because he's only a year or so older than me. And then I realized, you know what? I could be a grandfather anytime. You just never know. So God willing, it'll be at least a few years away. But so what does a meaningful win look for like you at this stage in your career? What are you looking for when it comes to cases? What are the things that keep you going and just energize you and make you want to keep doing this 35 years in?
You know what? It's really all about trying to help people. I really like what I do. I'm fortunate in that respect. Um, I've been doing this for 35 years, and I'm with rare exception. I've always been excited to always come to work. I like what I do. I get excited to take an expert deposition. I get excited to take a defendant doctor's deposition. I get excited when we get some new piece of discovery in. We just got a surveillance video in on a case that we were trying hard to get from one of the from the CTA here in Chicago, and it demonstrates what happened in the accident very clearly. So I just get excited when those things happen. I still enjoy the process. I like trying to help people. I like going over to court. So I just think that I'm lucky in that respect. I really enjoy what I do. I mean, it's a job, don't get me wrong, but I do enjoy what I do. I enjoy who I do it with. And even, believe it or not, I like who I have my cases against. A lot of the defense lawyers I've known now for, a while. You see the same faces now and again. And, some of us are getting older. We're all getting older, hopefully. But sometimes you meet someone who's a new lawyer on a case. And I just still enjoy it. I just enjoy getting up every day and going to work and trying to help people.
That's awesome. I think it's really good that you can have such a personable relationship with your competitor, with with the bad guy, right? With the guy on the other side of the courtroom, and not the
Well,
bad
it's
guy.
both the other plaintiffs' lawyers who do what I do. I said they're friendly competitors. I mean, we're all fighting for the same book of business, but you still see people over the course of time. And once they have a case, that's their case. You're not going to steal their case from them.
Yeah.
And you're happy that they have, that case, and you're happy to help them out. If they have a question. And for the defense lawyers, you know, um, yes, they're the opposing counsel, but they're not your enemy.
Yeah.
Um, Keep that in mind. And sort of back to my sports analogy, I played a lot of sports growing up, and again, you're competing. But you don't have to hate the other team. You can compete
Yeah.
against them as hard as you can. You play as hard and as fair as you can, but you don't have to hate them. They're not your enemy. They're not bad people, generally speaking. So you just
And you
try as
only
hard as you
spike
can.
football when you
Try
really
as
need.
hard as you can to do the best you can um, for your client.
Absolutely. That's good. Um, so all of that's good stuff. And actually, again, I want to be respectful of your time here. So what I'm going to do here in a minute, Ken, is I'm going to jump back over. I actually lost my notes that I had pulled up here a second ago. I don't know where my calendar went. But here in a minute, I'm going to jump back over and we're going to take a look at your site. And then I'm going to come back and give you our closing questions. I'm going to give those to you now just because I wanted to give you a little bit more
Okay.
time to percolate on those concepts.
Yeah.
So question number one is going to be, if you could change one thing about your law firm, the way it currently runs, who's there, where it operates, or what was the one thing, if you could just magically change one thing about your firm, what would you change? Number two, if you can go back in time, meet young Ken and give him some advice other than buy a lot of Bitcoin and hold to 100K, what advice would you give yourself and why? And number three is, if I gave you my magical pencil, and with this magical pencil, you could strike one law from the books, edit a law, or make a change to a law, what law would you add, edit, or change? While you're percolating on that, I'm going to jump over and take a look again at your website. I am talking with Ken Hoffman. Ken is on the masthead, one of the partners over at Mitchell Hoffman and Wolf, which are Chicago personal injury lawyers. They are focused on your recovery. And Ken's personal slogan is, I work for you. If you've been injured in the Chicago area, I think Ken sounds like he has a wonderful history, great experience, would be a wonderful resource for you. And the thing I love about PI, and I say this a lot, my listeners know that I feel this way. I love PI because you make law accessible to people that couldn't afford it otherwise. So if you've been injured, step number one is figure out what your rights are. Because as the tagline of the show is, if you don't know your rights, you don't have any. And with PI, give them a call. Talk to them. That initial consultation is always free. And it may be the case that you don't have a case. You know what? But if you do have a case, the sooner you get moving, the better. So visit mitchellhoffmanwolf.com. Again, we'll have links down below in the description to the website, or give them a phone call at 312-726-6722 and schedule a time to speak with them. If you happen to see them because of this show, please feel free to let them know that you found them due to the attorney post interview as well. Our last sponsor for the day is Rank with News. A quick question. When someone Googles your business or your firm, what do they actually see? Is it just your website, or is it real authority, major media, credibility, and trust? Because the firms and the businesses getting chosen today aren't just visible, they're validated. And that's where Rank with News comes in. We feature major businesses like yours in Business Insider, Yahoo News, Yahoo Finance, AP News, and so on. And when prospects look you up, they don't just find you, they find trusted resources telling them to trust you, and then they trust you. This isn't about ads. This is about owning your reputation at the moment it matters most. If you want to stand out in a crowded market and turn visibility into credibility, visit rankwith.news or rankwithnews.com to learn more about how it works. That's rankwithnews.com. All right, Ken. So you have a magical wand, and with this magical wand, we can make one change to your law firm. If you could change anything about the firm, what would you change?
Um, it sounds a little bit hokey that we could help more people. I mean, too many times people come in, use a medical malpractice example, is that they come in and they didn't get great care. They were probably shuffled around a little bit, but they didn't suffer any real cognizable injury, but they were mistreated by the healthcare system, we'll say. But end of the day, unless there's an injury that you can prove in a court of law, something, bad bedside manner, or things like that. Those really aren't negligence that you can prove a case on. But people will tell me that they went to the emergency room 2 or 3 times before they were ultimately diagnosed, and they got their diagnosis on the third visit, and they want to sue for those first two. But there's really no injury between the day of the first visit and the second or third visit 2 or 3 days later. It didn't change their outcome. But again, they were not treated properly by the healthcare system, and that's a deeper discussion than we can have time for today as to why that happened. But you have to help more people in those situations. Um, and sometimes there's just not any negligence at all, going back to the slip and fall situation or the auto accident situation. People come with bad injuries and sad stories. But if there's not liability there, we can't prove the case. Being a contingent fee law firm, you can't take it on. So we can't help everyone who comes in, despite the fact that we'd really like to do that.
Yeah, no, that makes perfect sense. That's good. And you're absolutely right. I'll tell you, it's not something I talk about very often. It's one of the things my mother passed away a few years ago, and it was a slip and a fall, but it was in the home. There's nothing you can do about that. Like it's her own house, and she just was. I think there might even have been a case there because she was definitely kind of in and out of it towards the end of her life, and maybe she should have been under better care. But there was only so much we could do, and I'm hours away and whatnot. So, yeah, sometimes you just have to kind of accept that sometimes people just get hurt in life, and that's just life, I guess. Okay, question number two. We travel back in time using the power of time travel, and we meet young Ken Hoffman, maybe 1994, maybe fresh out of law school, and he's got kind of a silly looking 90s haircut or whatever. And you're able to go up and without breaking the space-time continuum, whisper a little bit of advice into your ear. What advice would you give yourself starting out?
I think the one thing that all young lawyers have to remember is that it doesn't matter how good of a lawyer you are or how smart of a lawyer you are. You have to go out and you have to develop relationships and ways to find business contacts and things like that. Sure, you can advertise on television, which plenty of people do. You can appear on podcasts the way that we're doing today. And it's a great way to get your name out there, and it's a part of what we do. But you need to meet people. You need to go out, join bar association committees, join whether your church or your synagogue's board of directors or be on a committee there. Join a local club of some type, whether it's the Rotary Club or other things that are in your community. Get involved, meet people. The best way to develop contacts, develop business. And I think early on, I thought all you should do is work, and be at your desk. But ultimately, you're not going to find business just sitting at your desk. Get out, meet people, be part of the community, be a good citizen.
Yeah. No, that's good advice. Just in general, be a human being. The bigger your social circle, the better you're going to do just in general. That's a truism of life. So I agree. All right. My favorite question, potentially, other than the most absurd thing you encounter is this. I gave you my magical pencil. Now this pencil, it's one of those Bic pencils and the lead is about to fall out. There's not much left in it. However, there's just enough of this magical graphite that you can go in and you can make one little change to a law. You can strike it from the books, you can add a new one, or you can just make an edit to a law that's already on the books. If I gave you this magical pencil and you could make that one change, Ken, what would you change and why?
I think I'm going to give you two laws I'd like to have changed. One is in Illinois, before you can file a malpractice case, you are required to obtain a certificate of merit before you file the case. And that was passed back in the early 90s, I want to say, as long as I've been around. And it was done to decrease the number of, quote, frivolous lawsuits that were filed against doctors and hospitals. And I am not in favor of frivolous lawsuits We try as hard as we can to screen all of our cases. But that requirement means that when a plaintiff wants to have the case reviewed, they are required to have the medical record reviewed by another physician who's knowledgeable in that area of medicine. Sounds reasonable, sounds great, right? We don't want
Yeah.
bad lawsuits.
It sounds like a stopgap.
But here's the problem. Who gets to control what goes into that medical record? The defendants themselves. So you're being forced to review the case based upon a piece of evidence that's created entirely by the defendants themselves. So I think that that law sometimes prevents meritorious cases from seeing the light of day. So I know there's a bit of a yin and yang to that on both sides, but there is that's always rubbed me the wrong way about that law. I know it's supposed to cut down on bad filings, but I think it also gets in the way of people properly evaluating what might be meritorious cases. That's the first one. Second one is, I think the state minimum auto insurance requirements here in Illinois are only $25,000. I think that's just too low. I think that when there are serious injuries, and people who cause them only have a $25,000 insurance policy, you're not protecting the public as the law is designed. I think that needs to be looked at. I'm not saying it should be $1 million for the state minimum, but I think $25,000 is too low, and I don't think reflects the benefit to society that that law is designed to put in place and protect. So I think those are my two things I would tell you in answer to that question.
Gotcha. Well, that makes perfect sense. And yeah, that first one, the having to go through the defense more or less to find the merit, that, I mean, that just feels like an attack on justice at the end of the day. Like, if you're preventing justice from actually happening, that's a bad law, and that does need to be changed. So, and I agree with that 100%. Well, Ken, I really appreciate you taking the time to talk with me and my listeners today. I do always like to let my guests have the final word. Are there any last words of wisdom or parting thoughts you'd like to let our listeners know?
Well, one, I want to thank you for having me on the podcast today. Really enjoyed the conversation. And what I would let our listeners know is that if you ever have a question involving a personal injury case here in the Chicagoland area, reach out to us. Happy to answer any questions that you may have. If you're a lawyer from outside the city of Chicago who has a question about a personal injury case, auto, trucking, malpractice, worksite accident, give us a call. Happy to answer any questions that you may have. Keep in mind that, the first consult is free. We work on a contingent fee basis. And unless we're successful for you, there is no charge. And for lawyers out there who are looking to consult with a lawyer here in Chicago and possibly refer a case, we are always open to referral arrangements in conformance with whatever ethical rules exist in that realm. And a lot of our cases do come into us from lawyers who are from outside the city of Chicago, outside the state, who have a case that need or help with here in the city of Chicago. So please reach out. Happy to answer any questions anybody has. Email, call, text. I'm always there for you.
There you go. And he works for you. That's the tagline. So very good. Well, Ken, thank you very much for, again, taking the time to meet with me today. I really do appreciate that. As always, this has been The Attorney Post. I am your host, Justin West. As always, I've been chatting with Ken Hoffman, who is on the masthead over at Mitchell Hoffman and Wolf. As always, while this podcast does deal with a lot of different legal issues, this podcast does not constitute legal advice. And should you find yourself in the need of competent legal help, I strongly recommend you find an attorney in your area who specializes in the area that you need. However, if you've been injured and you're in the Chicago area, I think after this conversation, I can highly recommend Hoffman and his law firm. I think you will be in wonderful hands, and you should definitely visit mitchellhoffmanwolf.com. mitchellhoffmanwolf.com. We'll have the link down below in the description as well. If you've been injured, give them a call, because, again, step number one is just knowing where you stand and knowing what your rights are. Go ahead.
And there's also mhw.law is also our website. MitchellHoffmanWolf.com is a lot to say, as Justin just said. So that was the initial website, but then they opened up the .law domain. So we shortened it to mhw.law. So if you look at Ken Hoffman Lawyer Chicago or mhw.law, you will
that is stupidly easier, and I'll try to remember to put that one down there. I'll tell you right now, the main reason I didn't put that in there is I knew that was part of your email, and I didn't know if that was just your email domain, and I didn't want to give it away. So, but since you're willing to give it away, That definitely works. MHW.law, MHW.law. Very easy to find. You've seen the website. Scroll down, give them a call, fill out the form, whatever it happens to be. As far as the podcast goes, this is again Ben the Attorney Post. If you are listening to us on any of the podcast repositories, Apple, Stitcher, Spotify, etc., please like us, rate us, etc. If you're on YouTube, leave a comment down below, subscribe, share, etc. But the most important thing you can do to grow this podcast is simply this. If you know somebody who would benefit from the information contained in this particular episode, particularly somebody injured in Chicago, let's say, share this episode with them, because again, if they don't know their rights, they don't have any. Until next time, this is Justin West. Thank you guys for listening, and stay safe.